House Oversight Committee will come to order. Clerk, please call the roll.
Mr. Chair.
Here.
Representatives Kelly, O'Brien, Leonard.
Here.
Auerlack.
Here.
Townsend. Robinson.
Here. I took
Phelps.
your bill
Chair,
from my bill
not yet.
that was laying on top of yours.
We don't need it. We're not going to be voting on bills, and I know that there are two other committees happening right now, and so I believe one of them is going to get out relatively quickly, and we'll be joined by a few others. But I did want to get going on this this committee. We've got some really important issues. We've got some people that have traveled distances to get here, and so I'm very excited about the topic and about the legislation, partially because a couple of the bills are mine, but also because it's good policy. And so we're gonna take up a bipartisan package that puts reporting requirements into different types of forfeiture that the government. We're talking about government seizing assets and potentially seizing them without ever a conviction happening. And so if we are going to continue this this procedure in the state, I have bills, and Mike, Representative Carlton and Representative Robinson, if you two wanted to come forward. The three of us have this bill package, and just briefly, I don't know if you want to share anything about it. I became aware of civil asset forfeiture as I've gone to various groups and explained what it is. They are somewhat befuddled residents that it actually occurs, and perhaps it should be occurring in some instances, but I think this legislation where it would require reporting so that we know how much is being seized and forfeited, how much is being forfeited without a conviction, how it's being used, what kind of assets are being forfeited. I think these are all important details that we should be shining the light on, and so that's kind of my interest. Either of you wanted to, if you wanted to say anything, you don't have to say. We're going to have plenty of people, but yeah, go ahead, Representative Pelton.
Thank you, Mr. Chair. I first became interested in this, in the topic of medical marijuana, and several cases that I found out about where people were raided and their property taken, cars, equipment, money taken, and charges possibly never brought, or an acquittal where they're deemed innocent, but yet they forfeited their assets. And this concerned me because I always thought in this country you are innocent until proven guilty. And in this case, people were innocent or charges never brought, but yet they were punished. And so my bill, part of this package, is House Bill 5252. It will add reporting requirements to the Uniform Forfeiture Reporting Act to the revised Judicature. Thank you. I'm not a CPA or a lawyer or this or that. Those agencies affected would be mainly law enforcement and mirrors the language in House Bill 5251. Thank you, Mr. Chair.
All right, thank you. Representative Robinson, did you want to?
Just briefly, I just want to thank the chair for holding these hearings. I think it's critically important to all the people in Michigan that we have some transparency, we have some understanding of how these laws work, that we are not going to seize property from innocent persons under the drug forfeiture. And when I say innocent, presumed innocent. They're not been convicted. And there has to be, I don't want to see those individuals used to enrich and to fund the police agencies throughout the state. There has to be some accountability, because it tends, whenever one looks at that situation, it's open to abuse. I've seen it in Wayne County, where there is terrible abuse under the nuisance statutes, forfeiture, and sort of like blackmailing citizens. To get your car back, you pay $900, and they've never been convicted. They've never even been charged. It's an abuse that has to be prevented. We have to prevent the abuse, and we have to also have an open, transparent view of how this money is spent and where it's going and what's motivating our police agency and our prosecutors to pursue this route. I just think there has to be a check on the abuse, and there has to be transparency.
All right, good. Thank you very much, and we're going to have some really good testimony, so any questions? Oh, I'm sorry. Representative Leonard.
Thank you, Mr. Chairman. This one's actually for Representative Robinson. Representative Robinson, I know that you've probably represented, what, hundreds, thousands of indigent defendants throughout your career. Is that correct?
Yes.
Representative Colton had mentioned that there were cases or individuals that were having their property seized, never getting it back, and there was never either a charge or they were acquitted. Did you have those types of scenarios when you were practicing?
No, what I did, Mr. Representative Leonard, I represented the criminal aspect. I never did the civil forfeiture work. I wasn't a civil practitioner.
Okay.
That's a different proceeding when it comes to forfeiture. But my clients would have their property taken, even though I proceeded with the criminal defense. Their property in thousands of cases was confiscated. And it was just a shakedown. Someone has dope on them. They're charged with possession of cocaine. They have cash on them. They have a watch. They have whatever. It's stripped. Then they are forced to post a bond. They don't have $250 to get back $140. So it's become, what I say, without seizure of property, without protection, with due process, minimal due process protections. And I think we should show, and by doing my bill would cause them to report, and then you'd see a pattern. You'd see people whose property is like $60 in their pocket, or a cheap old watch. But it all adds up, and especially in the area of prostitution, which my bill doesn't address, but as a nuisance. The cars are just seized. A man rides around circles where some girls are working or young women are working as sex workers, and his car is seized by the deputy sheriff. And then the mother, the grandmother, has to go down there and pay, if it's their car, have to pay $900 to get it back. It's a racket in my eyes.
So, despite the fact that you didn't work on the civil aspect, you were just on the criminal aspect, did you have clients, though, that you're aware of that did have property seized, they didn't get back, despite the fact there was no conviction or a charge? Are you aware of scenarios?
Yes.
Okay.
And even if they're convicted, they don't have the resources to defend to get that money back. And if you have $50 in your pocket, it doesn't mean that's the proceeds of having the cocaine. It's just an enrichment for the state that's unfair.
Thank you.
Thank you. Anyone else? And we are talking tens of millions of dollars. I think we're going to hear a little bit of testimony about some of the numbers. And obviously, not all are bad actors. There's plenty that do it right. We're talking about transparency that would actually probably justify those that are doing, I think if you're not doing anything wrong, we're told all the time that citizens are not doing anything wrong. What's wrong with transparency, watching watching what's going on, which I have some concerns about, but I certainly think if the government isn't doing anything wrong, they shouldn't have any problem with transparency. So I appreciate both of your sponsorships on this package, and let's get to the experts. Thank you.
Thank you.
First up, Mr. Speaker, do you have time? Because I was going to bring Lee up. Are you okay with time? Okay. First up would be Lee McGrath. He is with the Institute for Justice, flew in from Minneapolis, and is legislative counsel for the Institute for Justice, and we're honored to have you here. And Lee, we've worked together by phone, and it's good to see you.
Mr. Chairman, it's also good to see you, and to the members, I thank
hit
you.
the button there.
Mr. Chairman, thank you. It's good to see you as well after these many phone calls. My name is Lee McGrath. I'm the Legislative Counsel for the Institute for Justice, and thank you for the opportunity to testify today in favor of this package of very good legislation. Civil forfeiture represents one of the biggest threats to property rights and due process rights in this country today. The Institute for Justice has long litigated and lobbied to protect those rights. Most recently, we represented a supermarket owner in Fraser, Michigan. We've also represented a motel owner in Tewksbury, Massachusetts, when they faced federal forfeiture charges. and we have represented people in Georgia and Texas who have faced state forfeiture. I've also lobbied this very bill in Georgia, and my colleagues have done it in Maryland, and I support fully what you're trying to do. My law firm, the Institute for Justice, is best known for losing a case at the United States Supreme Court, Kelo versus City of New London. It was an eminent domain case, and we look at forfeiture through the same lens that we do eminent domain.
We were losing you. Yeah.
Okay.
Yeah,
I'll sit closer.
Yeah,
Thank you.
that'd be great.
My law firm is best known for losing a case at the Supreme Court, Kelo versus a City of New London, and we look at forfeiture through the same lens as we do eminent domain. When can the government take your property? What restraints are there on the government's taking your property? I support this bill because your state constitution gives you, state legislators, the sole responsibility to raise and appropriate funds. Your predecessors who enacted this bill have delegated that responsibility to the executive branch. The executive branch, under Michigan law, as well as other state laws, can act independently. It raises at least, we know, $20 million a year through seizures, and it expends that money without your knowing anything about how that money was raised or how that money was spent. Your predecessors have abdicated taken away your responsibility to control the funding of law enforcement in this state. This bill is an important means to address that abdication. It provides you with the information necessary for you to make, in future years, important public policy decisions. I'll give you an example of what just happened yesterday in my home state of Minnesota. Yesterday, Governor Dayton signed legislation that requires a conviction in criminal court as a prerequisite to losing property in civil court. That bill would never have gotten passed had we not known the details of how forfeiture is used in Minnesota. Because of reporting requirements in Minnesota, similar to what is in this bill, we know that the idea that law enforcement uses forfeiture only against large drug cartels is incorrect. We know that the average seizure is only $1,200. So the incentives are for law enforcement in Minnesota are for law enforcement to use forfeiture, seize those assets, because it is completely irrational to go and hire a criminal defense lawyer and spend thousands of dollars to try to get back $1,200. And Representative Robinson, I think the reason why the reason why you never represented anyone in civil court regarding forfeiture is because you were a public defender.
Well, I did. I was not a public defender, but I did mostly pro bono and indigent work.
Pro bono indigent work. Well, under federal law, one of the problems of having a two-track system in which the person is in criminal court but his assets are in civil court is that public defenders are prohibited by federal law from representing people and representing their assets in civil court. And so oftentimes these small dollar amounts, as we've seen in Minnesota, the person rationally just walks away because he can't get proper defense. It doesn't make sense for him to hire a criminal defense lawyer and he can't get a public defender. That is not to say that the same dynamic is occurring in Michigan. What it is to say is that this reporting bill is essential for public policymakers, for you to gain more insight into what exactly is happening, what type of seizures are occurring, whether people are getting proper defense. And so this is the foundational information that is essential for good public policy in an environment in which we know human nature rules and that financial incentives exists for people to, for law enforcement to look at, for some members of law enforcement to look at this as an alternative source of supplementing their budgets. With that, Mr. Chairman, I'm happy to answer questions about the work of the Institute for Justice, our cases, and the legislative efforts that IJ is involved in across the country.
Well, maybe you could just briefly mention about just civil asset forfeiture. What exactly, what can happen as well? I mean, that a piece of property is assumed, you know, is a defendant, right?
It is.
And could you just kind of briefly explain for those that may not exactly know how the civil asset forfeiture procedure occurs?
Happy to, Mr. Chairman. Civil forfeiture is a legal fiction. If I'm driving in Lansing or in Detroit or in Kalamazoo and I get stopped for an alleged crime, my person goes into criminal court. But my car and my cash go into civil court. Title transfers at seizure, and then I must file a lawsuit. I think it's within 20 days. I think in certain crimes I must post a bond. But I must simultaneously engage in a civil lawsuit against my own property because title has transferred at seizure, all the while I'm seeking criminal defense on the person side of this two-track system. Now, Michigan doesn't have to do it this way. Most states, unfortunately, do. But North Carolina has chosen not to. North Carolina has a single track. It only has criminal forfeiture. And so my person, my car, and my cash all go into the criminal justice system. There I might qualify for a public defender. There I might enjoy constitutional protections against illegal searches. But the two-track system that is used in Michigan, Minnesota, and most other states creates this legal fiction that somehow on the civil side I must prove, in Michigan, the government must prove that my car is liable for the crimes associated with it, and my cash are the proceeds of that crime.
And like you said, though, there's your car does not enjoy the constitutional rights, so an illegal search, while it might, in criminal, might get the person off, your car doesn't enjoy that, that defense. Is that right?
Mr. Chairman, that is absolutely correct. Constitutional protections are best developed in this country as it relates to the criminal justice system. They are less developed as it relates to the civil system. So I could be acquitted in criminal court or the case thrown out if the stop or search were illegal. But my car in this two-track system or my cash in this two-track system could still be lost.
Okay, Representative Howard?
Thank you, Mr. Chair. One of the things that I deal with, and in this particular issue, is when I talk to educated people, they think I'm making this up, and including people that maybe have been in courts of law before. Two things. One, do you have any way of, do you have an opinion as to why this is so, quite frankly, it's the best kept secret, if you will, for additional funding for certain government entities? But more importantly, if you could, I think it would be really helpful if you could just walk us through a case, an actual case that you're aware of in state court. It doesn't have to be in Michigan, it could be in another state, just to put you know, an example into play to really show how this comes into play.
Mr. Chairman, Representative, if I could, let me tell you why it once made sense and how it is different today. If you indulge me with a little bit of Anglo-American jurisprudential history. It once made sense for the King of England to create this legal fiction in cases in maritime law where shippers in the 17th century weren't paying their tariffs or weren't sailing under the British flag. The King of England could not get his hands, gain personal jurisdiction over the ship owner. And so he created this fiction of the cargo and the ship being liable, being guilty of failing to pay taxes. Well, this is no longer the case today in the United States. Law enforcement is able and apprehends people it suspects of creating a crime, and so it pulls them, it gains personal jurisdiction and pulls them into the criminal justice system, but still the idea of civil forfeiture exists. It was popular during, as every NASCAR fan knows, it was popular during the Prohibition, and it continued in the prosecution of illegal contraband controlled substances. An example of this, let me give you an example of a case, an innocent owner case in Michigan, a famous Bennis case in which Mr. Bennis is stopped for the nuisance crime of soliciting a prostitute. Mrs. Bennis had no knowledge of Mr. Bennis's activities, but she was a co-owner of that vehicle, and she wanted to get it back. So she engaged in the civil forfeiture process of filing a lawsuit against that car and tried to get it back. Unfortunately, Michigan law does not recognize, as it relates to nuisance forfeitures, vice, such as prostitution, the state law does not have an innocent owner claim, and Mrs. Bennis ultimately lost on due process claims at the United States Supreme Court. And so in forfeiture law, you have two potential people bringing claims. You have the person who is arrested and is in criminal court, but he's trying to get property back, and you have his spouse or some other joint owner claiming that she had no knowledge about the activity of the spouse and the criminal activity of the car. Does that answer give you a sense of it?
Okay. And also, they may not be in criminal court. They may not want to. I mean, they may not have ever been charged, but they just don't want to spend the $800 to get their $200 back that was seized.
Economics is a real issue here, and you're right, Mr. Chairman, that that you do not have to be this fictional world, this fictional two-track system, means that oftentimes nothing that happens in criminal court matters to what happens on the civil side. And North Carolina is wisely united these two processes into one, got rid of civil forfeiture, and has only one process, which is criminal forfeiture.
Yes, Representative Robinson.
Yeah. I'm sure you're aware there was a time period where it looked like the federal courts were going to apply double jeopardy. You know, we had a couple of cases, a few circuits. The North Carolina, does that would implicate double jeopardy, wouldn't it, if they used it in one, the punishment and the crime are together in the criminal process? It
would eliminate, Mr. Chairman, Representative Robinson, it would eliminate the possibility of double jeopardy, because you're all doing it, the prosecution against the person and the vehicle and the cash are all occurring in one process. And so you have that implicit prerequisite of the person being convicted and in the same court, the judge or jury determining that the car and the cash are the instrument and the proceeds of that crime that the suspect has just been convicted of. Had he been, if the suspect is acquitted, then it's answered. He gets his car back, he gets his cash back. And so there's no double jeopardy, there's none of this fiction of the car being independently liable for the crime.
I appreciate your bringing forth the lack of a defense of the innocent owner. That's where I see all the abuse. They have dozens of cars every day where the grandmother or the sister who owns the car has to put up the money to get it back. And they don't file a lawsuit in Wayne County. They just say, bring us $900 and you got your car back. To me, and then the idea of the defendant or the person who's accused or arrested, he's not going to put up a $200 or $250 bond if he has $60 in his pocket. Or, and it's accumulative. It builds up when you arrest 1,000 people with drug cases and you confiscate under, I know there's 1,200 in Detroit, it's probably under $200, whatever the bond is. But it's just, it's so unfair. But anyhow, I appreciate your comments. I'm not going to be on a soap opera, but soapbox here. But your comments were right on point, and you demonstrate more articulately than I could some of the problems. Thank you,
Mr. Chairman, Representative Robinson, thank you for your acknowledgement. This is why this bill is so important, because today the State Patrol does a good job of reporting some, as I'm told, some of the forfeiture activities that are going on. We know from this most recent state report that the forfeiture amount totals in statewide about $22 million. So that's a good signal that this committee is right to hold this hearing, and it's a large enough number to raise eyebrows. But what the bill importantly does is give policymakers more details as to which direction legislators should take this issue.
All right, and I think also that people that have their assets seized, potentially, they may not want to try and get them back because they may not have been charged, and they're afraid that if they try and get their assets back, they may end up getting charged, even if they didn't do anything wrong. So I would imagine, and have all that hassle, so I've heard that that's an issue. And also the level, you have to have unanimous, the jury has to say unanimously that you're guilty. I don't think there's a jury that says your car, it has to be unanimous for your car to be found guilty. Is that right?
Mr. Chairman, you're right, and oftentimes these civil cases occur when they do get filed. When someone takes what might be an irrational step of filing the lawsuit, McGrath versus $1,200 in U.S. currency, or McGrath versus 2003 Chevrolet Impala. Often it's a bench trial. But if I could add, Mr. Chairman, one additional thought about this. I applaud your holding this meeting, this hearing, but I want to make clear that I'm not a carpetbagger in the sense of every state but North Carolina has these issues. The issues that you're grappling with are not unique to Michigan, but what is encouraging is that you're taking somewhat of a unique step of gaining more information to learn about how seizure and forfeiture are used in your state.
Thank you very much. Thank you. Next up will be former Speaker Craig DeRoche, President of Justice Fellowship. Thank you very much for coming.
Thank you, Mr. Chairman. Thank you, members of the committee, for allowing me to come and present today.
Yes.
Justice Fellowship supports the package of bills 5081, 5250, 5251, and 5252, and for some very important reasons. What is being debated underneath these bills. And I don't want to diminish the importance of disclosure and accountability that these bills begin to bring us on the path toward. But we are talking about first principles here. You know, we are talking about moral hazards. We're talking about things that can be described properly as theft. You know, when property is taken from an individual and that is made legal, but there still was no basis for the acquisition of the property to begin with. Those are first principles. That is a value that every resident of the state of Michigan should be concerned with, because they would recognize that as theft if it was being described as something that occurred from neighbor to neighbor, or from a stranger coming into their home and taking a car or something along those lines. And I think that we lose track of the moral principles that underlie the bills when we talk about them when there's law enforcement and the government involved. But I would say, Mr. Chairman,
great things
one
that
of
our
the
country has done that has separated us from other countries is we have kept at the federal level our armies from being able to receive the proceeds of any acquisitions that they acquire in the prosecution of the wars. And one could easily see how that would seep into the decision-making process if at any level in America we thought that it was acceptable to reap benefit, plunder, if you will, to fund our activities. And yet at the state level and at the federal level, when it comes to prosecuting crime, we've done just that. And what we've done is we've done a disservice to our law enforcement community, the prosecutors and the police, because we've put them, when we say a moral hazard, we've put them in a situation where they have a powerful incentive to trust in that goodness will prevail, knowing that it is humans that will be working within their departments, prosecuting the violations, running the court systems and the like, and to put these powerful incentives in place for them to pursue and prosecute these civil asset forfeitures, as I say, is doing them a disservice. I think that these bills are modest, and I'll give some specific testimony to the bills, but I believe it goes in the right direction. But I would implore and encourage all of the members of this committee to look at this from the sense that this is a directional relief to law enforcement and the prosecution in the judiciary in America. Whatever level of accountability, oversight, or the pulling back of this authority from them, I believe will give relief to these agencies to be able to do their jobs without these conflicts of interests. Bringing transparency in these bills when government seizes property from citizens, though, should be of the highest interest of this body that you all serve in. The type of transparency is important to maintain the accountability. In these bills, they strengthen the citizens' ability to protect private property and reinforce the idea that due process must remain a touchstone in our legal system. The government must not be able to seize property without being held accountable when it makes a mistake. That's another principle that isn't directly pursued, but one that Justice Fellowship would encourage the representatives to continue to pursue, that government does make mistakes. There are dismissals in criminal cases. There are not guilty findings, and yet there is very little accountability for the government. And the government receives its credibility to hold people accountable for their mistakes to the extent that they are willing to be held accountable for their own mistakes. And what we've done is we've moved away from that. Asset forfeiture, as I've stated, creates a moral hazard for law enforcement and other state agencies. Too often these government actors use seized assets to strengthen or grow their organizations. This creates a conflict and not just a moral hazard, but a morale hazard for people that believe that are charged to work within this system. This goes against their first principles of how they, the values that they hold up in their own families and in their own lives as they pursue their professional employment and law enforcement. Asset forfeiture is a way to punish citizens without first meeting the legal requirements generally associated with criminal law. It erodes due process and as a result diminishes a respect for authority and our system of justice. Increased transparency will create confidence among the citizens, which will foster trust and respect for those who are charged with enforcing our laws. It is a fundamental principle of our constitutional republic that the government can only deprive a person of life, liberty, and property when due process of law is followed. These bills would make it easier to follow due process and correct the wrongs when they occur. And as I've stated multiple times, I believe, and Justice Fellowship believes, actually give relief and support to law enforcement community in the state of Michigan by allowing them this transparency that's afforded in these bills. Thank you, Mr. Chairman.
Thank you. Yeah, I guess you mentioned incentives, and I guess there are, I've forgotten to talk to or mention it to Mr. McGrath, but I think there are ways to kind of change the incentives as well, and we might, through this transparency, understand that maybe we make it so that any seizures go into the general fund as opposed to, back to the law enforcement, so that the incentives, I think changing the incentives might be another outcome that would be reasonable policy that we would result from these transparency bills.
Absolutely. It's been said that he who robs Peter to pay Paul will always have the support of Paul. And I think the representatives would be wise to recognize that the seized money does create a powerful incentive and a moral hazard. So allowing that to be moved up before it's redistributed out would provide a key check and balance on the underlying incentive for pursuing the property in the first place.
I think you bring up a really good point about credibility, because we know the vast majority of law enforcement prosecutors do a phenomenal job and put their lives on the line, and we appreciate them. And I've got to believe that they don't appreciate and would love to have exposed the bad actors. I mean, the idea that just trust us and everybody's doing everything right, I mean, we know that doesn't occur, so let's just make sure that we put in systems so that those vast majority of people who are doing wonderful and doing heroic things, they don't have to worry, about some of their colleagues that they've loved. I think that they probably want that exposed, don't you think?
Well, and that's the point I'm trying to raise, and why I bring up first principles and the values that people hold within themselves in their workplace. I'll give you an example of a federal court case that was just a case that was thrown out where officers were taking people that otherwise were crime-free and telling them to hold up a drug house for money, but the drug house was actually full of law enforcement officials, and that they would pay them money to do it. And then they were arresting this. When the judge heard of this, he said, what a preposterous thing. And even though the person went in there with a gun to hold up and to hold people, law enforcement people up, the whole thing was staged by law enforcement, and the judge threw it out and said it was the most preposterous thing he had ever seen. And I think the same thing when I think of asset forfeiture and seizures. What are we putting in the workplace where people say, I might have to do this to fund my job. I might have to do this because of the budget constraints that we have in our city or our county. That we might need to do this because I can't let so-and-so get laid off because he's got young kids. And inside of me, my values are different than that. But I'm being asked to do something to generate revenue. When I say a moral hazard, I want to give you exactly what that looks like and it feels like. It's inducing somebody, putting out a moral hazard, a risk of them behaving in a moral, upstanding, in a way that is consistent with the values that they hold dear. And that's why I think that removing these moral hazards is something that will, by and large, benefit the law enforcement community, including the command structure that answers for these budgeting decisions. I think they would benefit from having the moral hazard removed from their professional risk management of their job as well.
Great. Any questions? All right. Thank you so much.
May I make a comment?
Yes.
Yeah. I want to thank you because that moral issue is very important to me, ethics. And it borders on encouraging activity or injecting yourself into a situation which you know is not right, but yet you have to do it because it's expected. And like you say, there's the pressures of your fellow employees. Yeah, I've seen prosecutors who have personally expressed to me the uncomfortable feeling when they're forfeiting these cars or giving the cars back to relatives and collecting that $900. They don't feel good about it. It's not right. Without due process, without, the innocent owner should not be punished like that. But anyhow, thank you for that aspect of it. That's very important to me.
Well, I think it's very important to the, as I said, the employees of the prosecutors and the law enforcement and the judiciary in Michigan, and I think that you'd be speaking for them, where it's difficult for them to stand up and say this out loud by advancing these bills.
Thank you very much.
Thank you, Mr. Chairman.
Next up is Dan Korotkin with Deputy Legal Director of the ACLU of Michigan. Dan, thank you for joining us.
Thank you, Mr. Chairman, members of the committee. My name is Dan Korotkin. I'm the Deputy Legal Director.
So that when you turn, I want to make sure that you're on.
How's this?
Okay.
Yeah, okay. My name is Dan Korotkin. I'm the Deputy Legal Director of the ACLU of Michigan. We are very pleased that serious attention is being given to reforming our civil asset forfeiture laws, particularly following growing public awareness about forfeiture abuse around the country. We've reviewed and we support the bills before the committee because a robust reporting requirement will give us the ability to analyze how forfeiture laws affect Michigan citizens, and that's a solid first step toward making needed reforms to our forfeiture laws. I'd like to focus my testimony today on the abuses that occur under a particular Michigan forfeiture statute called the nuisance abatement law. And sometimes this flies under the radar because it's the word forfeiture isn't even in the law, because I don't think it was actually intended to be a forfeiture law, but it's become one. Let me describe it a little bit in summary. Historically, it was called, this nuisance abatement law was historically called the padlock statute. And it was originally enacted to allow the state to close business establishments that were covers for illegal operations, such as brothels, gambling dens, drug houses, blind pigs. And it allows the prosecutor, by its very terms, it allows the prosecutor to initiate a civil action to so-called abate the nuisance by getting an injunction from the court that padlocks the establishment for a year. That's the original law. And the owner of the property would naturally have the opportunity to go to court and contest the case and argue that the building should not be padlocked. Well, a few quirks and amendments to the nuisance abatement law have now led law enforcement agencies to treat it as a forfeiture statute, and a statute that lacks all of the procedural due process protections that we would expect, and it deprives Michigan's citizens of the basic constitutional rights that we really take for granted in a free society. So the trouble begins with how the statute defines the term nuisance, because it says it's there to help abate nuisances. Well, not only is any building could be considered a nuisance, but a vehicle can also be considered a nuisance. And it says that if the vehicle is used for illegal activity, it's a nuisance. Now, to make matters worse, the statute does more than allow the prosecutor just to get an injunction against the use of the nuisance property. Remember, that was the original intent. You were supposed to be able to get an injunction to padlock the building. Now, even though the general remedy for a building is the padlocking injunction to shut down the business, in contrast, for a vehicle, the state is allowed to take possession of the person's car, sell it at an auction, and then keep all the money. So courts have recognized that this nuisance abatement law has really become a forfeiture law, not just for padlocking illegal businesses to shut them down for a period of time, but now to just seize and take ownership of a person's car. Now, in theory, the vehicle's owner, they can challenge the forfeiture in court, as has been described before. In practice, that almost never happens. The police take possession of the vehicle immediately, even though the law, by the way, does not say that you can take possession of the nuisance property immediately, but this is routinely what happens. And then it's the owner's obligation to file a claim and schedule a court hearing. The wait for a court hearing, particularly in Wayne County, I can tell you, I have heard can be several months. Typically, the citizen would need to hire and pay for a lawyer who understands the complex law in this area. And because nuisance abatement is a civil action, there's no right to a court-appointed attorney if you're too poor to afford one. So taking advantage of this situation, and as the former speaker said, it's a moral hazard problem. There are all sorts of terrible incentives. You know, the police and the prosecutor's office have developed this extrajudicial process that really doesn't involve any court oversight or any due process. As soon as the police seize a vehicle, they notify the owner that if they're immediately willing to fork over a fee of $900, it's called a redemption fee, by the way, and plus they have to pay towing and storage fees. That will be a settlement, a so-called settlement of the nuisance abatement case, of the forfeiture case, and then their car would be returned to them promptly. So the citizen, they're left with two options, right? They can either hire a lawyer, wait months for a court hearing, and even if they lose, they could ultimately completely lose their car. That would be it. Or they pay about $1,000 in what's essentially a ransom payment, really, for the return of their car. So not surprisingly, most people choose the second option to get their car back. Some of them don't have the resources to pursue either option, so they never see their cars again. And it's extremely rare that any of these cases wind up in court, so that the due process issues really get taken seriously. So I want to move on and talk about a particular case that documents this kind of abuse, this kind of problem. There are many, by the way, there are many documented abuses, but I'll just focus on one. And that's the infamous Cade raid of 2008, which became an ACLU case and has been documented in the New Yorker by Jack Lessenberry, locally by Brian Dickerson in the Detroit Free Press. So the Detroit police raided the Contemporary Art Institute of Detroit, otherwise known as the CADE, because this nonprofit's organization was allegedly hosting fundraisers on their property without obtaining the proper permits from the city. Now, I mentioned before there was this law that's supposed to be known as the padlocking law, right? If someone's if a business is using their property illegally, there's this padlocking function. Well, instead of using the padlocking function of the nuisance abatement law to essentially shut down the allegedly illegal fundraisers, the police burst in with their guns drawn, with SWAT team commando tactics. They arrested everyone who was there, over 100 patrons who were attending this fundraising event, merely for being present, and then they confiscated all of their cars for forfeiture under the nuisance abatement law. Now, the law, the statute, the nuisance abatement statute says that vehicles are a nuisance if they are used for illegal activity. That's what the law says. But the police argued, and of course, this really doesn't get to court unless you're willing to hire a lawyer and go through this whole long process. But the police said that the cars could be forfeited because they contributed to the nuisance because they were used to drive the people, the innocent people who were at this fundraising event that was hosted by this organization that didn't have the correct permits. The cars were used to drive the people to the place. So therefore they were used for a nuisance, and they could be taken by the state and permanently forfeited to the state. That was their theory. One individual's car actually was taken, even though he didn't even park it near the cave. He had parked it at a friend's house and walked there, but the police still said, well, you used it to get to the friend's house, and then you went to the cave, so we're going to take it. And now look, the police did not pursue any of the criminal charges in this case, not one. But they insisted on this $900 redemption fee payments before returning any of the cars. About 50 cars were seized that night, so that's about $45,000. Now in the ACLU's civil rights lawsuit about this incident, it was revealed that the city keeps $600 from every fee paid for each car, and then the county prosecutor, and then I think it goes to the general state treasury, would get $300. And that the city of Detroit, which we all know they're hurting financially, but they had used the nuisance abatement law to generate over $1 million in revenue over the previous several years. I believe it was a 5-year period. Now, after several years of very costly litigation, a federal judge finally ruled that the seizure of those cars had been unconstitutional. But the city appealed the decision and then, as everyone knows, filed for bankruptcy protection. So because there's a bankruptcy, that case is now on hold indefinitely. We don't know whether it's really going to be, if there's ever going to be a final decision that'll be rendered. And police in Detroit and throughout the southeast Michigan area continue to raid establishments that they contend are illegal. And then instead of using the padlock law to shut down the illegal establishment, they, through a civil action that involves actual due process, they focus their resources on confiscating as many cars as possible and charging $1,000 to give those cars back. So to conclude, as I'm sure you can imagine, we have several suggestions for legislative reform when it comes to this kind of activity. But the bills being heard today really focus on reporting requirements. And so for now, I think I would just reiterate that we support these bills because there's a clear need for more transparency when it comes to the seizure and forfeiture of personal property. These reporting requirements will hopefully deter some of the more egregious abuses of the nuisance abatement law, such as the story I just told you all. And if they don't, then the legislature will have the data that they need in order to justify further reform should that be needed. These reforms are badly needed all over the country. It's not just in Michigan. But this is an issue that unites voices on the left and the right, and it goes back to first principles, as the former speaker said, and it's a really important step to take. So thank you, Mr. Chairman, and members of the committee for being willing to take this first solid step toward restoring the civil liberties of Michigan citizens when it comes to forfeiture abuse.
Thank you. So I guess what I'm hearing is that you obviously want other reforms, but at the very bare minimum, transparency and reporting so that we know what's going on is something that would be reasonable.
I think that's right, Mr. Chairman, and really for two reasons. One, we need to know what's going on, but what is the saying about sunshine being best disinfectant? Hopefully just by having more reporting requirements when a law enforcement agency knows that it's going to have to report what they're doing, that will deter, we hope, some of the more egregious abuses as well.
And there is a little bit of reporting, not that all of the agencies report to the state police, but I think that there's a high level, there's not much detail, and so that was, as I was crafting some of these bills, we wanted to make sure that there was more understanding of how many of these what kind of assets, You know, how much never had a conviction, what were they used, what was the proceeds used for? So, I mean, it seems that the more detailed, those are important details that should be known.
Yes, Mr. Chairman, and as well, I would note that a lot of times the reporting and talk about forfeiture just goes to the laws that use the word forfeiture, whereas this nuisance abatement law that I was just describing, sometimes it flies under the radar because people don't even say that it's a forfeiture law, even though courts have recognized that it is.
Do you know if one of the four bills captures that type of forfeiture, or would we need to make sure that it does for transparency?
The bills do.
Okay.
I don't know if current reporting requirements
Okay.
do, but the bills do.
Okay, good.
So.
And then finally, since you're an attorney, and I meant to ask Lee this also, between seizure and forfeiture, can you give the distinction there between, or Lee, you know, as far as the difference between the two?
Yeah, I think it's essentially like the difference between an arrest and a conviction, right? So the state first seizes the property and says, you know, that this is ours now, and then if there's no, it's then up to the person who used to own the property to come and try to contest that. If they do contest it, or if they don't contest it, if they do contest it and they lose, or if they don't contest it at all, then the property becomes forfeited to the state. But you know, one of the problems is that people lose their property before the forfeiture is final. Right. And then the state tells them, well, if you want it back, not only do you have to file this civil action, but in many cases you have to post a bond just for the privilege of contesting the forfeiture. And if your property's already been seized, posting a bond may not be affordable, and economically it may not make sense.
Lee, did you want to, because we talked before the hearing, and some would say if a robber takes assets, if you don't have them seized, they could get rid of the assets and sell them before, you know, the victim gets a chance to get them back. So there is a process there. Do you want to just?
I do, and Mr. Chairman, thank you for the opportunity. I've sat next to many members of the ACLU in this endeavor, and I welcome the opportunity to sit next to you. A very simple way, and let me augment that very good answer, is to think about that police officers and sheriffs are in the seizure business, and prosecutors are in the forfeiture business. And what these reforms, the reporting bills are going to shed light, but subsequent legislation, if you pursue it, will focus on the work of prosecutors. It will very likely not focus on the work of the police officer on the street. The police officer on the street has to meet some basic requirements of probable cause. But in general, that's a low barrier, a low hurdle, and police and sheriffs can seize things and can hold them for investigatory reasons. Nothing is going to change, likely, in reforms that you may consider down the road. The reforms that you will consider down the road are mostly likely going to affect the work of prosecutors in civil court, in terms of what burdens they have to prove. Who has the burden, whether it's the government or whether it's the innocent owner claimant. And so, I would, law enforcement, members of police and sheriffs and sheriff's associations can take comfort that day in and day out, forfeiture legislation that being considered across the country does not affect their work of apprehending suspects and seizing their property for investigatory reasons and for other reasons.
Okay. Any questions? Very good. Thank you very much.
Thank you.
All right. We do have a couple others who would like to testify. Is Amy still here? Amy?
I am, sir.
Okay. Is it Diener with the Michigan State Police? She'd like to speak for 5 minutes and opposes as written.
Good morning, Mr. Chair, committee members. I'll be very brief, sir. I know we spoke before the the hearing, and I'll try and be very brief and give the committee time to ask questions. I know this is kind of a complex issue and a lot of moving parts. We're opposed as written, and I'll outline a few of the things that just procedurally are not possible for us. A lot of what was talked about here earlier as far as transparency and better reporting are obviously things that we support as well. I don't think that in the many discussions we've had with other issues, those are things that we share as well. So I'm hoping at the very least just to provide you with some insight in the short amount of time that I'm going to speak this morning. One of the primary things, the scope of the reporting and looking at some of the other model legislation that I believe that this bill was modeled after, was still done on an annual basis. For our annual report that we compile now, we have one FTE that completes that. And of the responding agencies, he is tasked at pretty much max capacity in his role now in producing an annual report. So to do it monthly would require likely automation on the part of BTMB in order to include the scope of things that are covered under this bill. And likely another FTE, possibly 2 more, in order to do I believe it's 235 forfeiting agency reports that would have to be done every 30 days. So I know there was some brief discussion as well, the previous gentleman talking about seizure and forfeiture and the difference between the two. With law enforcement, and without getting into the actual specific definitions, as a police officer, any investigation that I have in some capacity could involve seized property. And that's just terminology that we use within the profession. For instance, if I have a criminal sexual conduct investigation that I'm doing, I could seize phone records, bank statements, computer hard drives, and I can go on and on. Many of the things that we do under the Controlled Substance Act are the same thing. So when we look at sometimes thousands of pages of phone records, bank statements, fingerprints are seized property. Anything that we take into our possession and has now become a trackable property item is seized within our terminology. Forfeited is when that person may or may not, by process, get that property back. And as the previous gentleman spoke about, the civil process that they go through to get that back. Seized property, from the police perspective, is oftentimes things that are taken and are either destroyed per departmental policy or are given back once the prosecutor has rendered a disposition of the case. So I guess we would ask for a little more clarification from that perspective of seizure versus forfeiture as the way the bills are written. The other portion procedurally that we just simply can't do is the withholding funds portion. Entities like MCOLS and OHSP are housed within MSP, and there are grant funds that go to local agencies. We don't physically write a check to these agencies. There's some different parameters, some different guidelines in place as to how those local agencies get the funding. We would have no ability to withhold any type of funding from local entities. So that's just something that is not possible. And the other thing that in some of our discussions that comes up is when assets are taken in, cash, vehicles, conveyances, whatever the case may be, by statute, those assets are to be held in a separate fund. So if a local agency is doing that, any of those proceeds should be taken in and held in a separate fund. And our question, and when I say our, I mean MSP, is if many of these agencies fall under the governing body of a city council, commissioners, and whatnot, are we ensuring that these local bodies are auditing, which they should be able to, as it's a public fund, whether through FOIA or just because it's a public fund, they have the ability to look. What's being done at the local level to ensure that local agencies are using the money as they should be? I guess that would be our first question. Before we look at a statewide mandate, what are we doing locally to make sure that these entities are tracking what their local police agencies are doing? That pretty much sums it up. And again, I don't want to take a lot of your time, but those are the primary points. And again, we're happy to sit down and discuss with you any changes that you want to make or different reporting formats. We're always open to that.
Sure. When we talked earlier, it seemed like there wasn't too much differences. I think that with the withholding funds, and I forgot to mention that the reporting, I've found that there has to be some teeth in
Sure.
things in legislation, so they would have their 20% of their funds withheld if they don't report. And then as far as what you were talking about reporting, I do think that if a local city seized a few cars and sold them, but then reported to you that they didn't seize cars, and I think transparency would kind of help aid that. But we can I wouldn't want to hold up this in order to get to dealing with at the local level. So, but I appreciate. Is there any question? Yes, Representative Leonard.
Thank you, Mr. Chairman. Going back, and Sergeant, right?
Yes, sir.
Thanks for being here. Going back to your second point, the seize versus the forfeiture, and I don't want to put words in your mouth. That's why I'm asking the question. Are you fearful that these bills in any way could put in jeopardy an ongoing investigation?
Potentially, and that was a point that was brought up as well. When we get into listing some of the reporting requirements, we feel could either put possibly an informant in jeopardy, or the unintended consequence is now a person who may not have been charged yet has their assets published online and are now hanging out there and can be tracked back through a little legwork on the part of anyone who looks at the report on the internet, and potentially could compromise a witness or an open investigation. Yeah, that's absolutely something that came up.
Is this something, and not to put you or the chairman on the hot seat here, but is this something that you think that you two could work together to come up with a resolution? I mean, is there any way to get around this with these bills, do you believe?
I think we would be open to discussions looking at anything that has to do with better reporting. We would and I believe I spoke with Rep. McMillan's staff yesterday on it, but in our annual report, the agencies that we do have, I believe 94% of the agencies respond. Of those, 45% report forfeitures. Now, that number could simply mean, that doesn't mean that not everyone is reporting forfeiture. That's simply agencies that are likely engaged in forfeiture. In a lot of the examples that were brought up here today, that certainly have to do with the one gentleman mentioned moral hazard. As a police officer, my entire job is in moral hazard. Everything we do daily, from traffic stops to contact with the public, we are often faced with very challenging decisions. So to that end, I don't have to take anybody back to the Omni scandal that went on in our department a few years ago and was embarrassing, and people were fired and went to prison over it, as they should have been. If there are individuals out there that are engaged in things that are illegal or gray to the point that they're illegal, I would encourage some mechanism where we target those individuals before we look at a massive overhaul of the system. But absolutely, we would be willing to look at anything that would improve reporting or what we report on.
Yeah, I think we can get there. I have no intention of posting that it was Mr. Jones's, 2012 Cadillac that he lived at 123 Oak Street. There's no interest in that being what's reported on. So, good. Well, it sounds like we will get there. And I appreciate you bringing up the moral hazard and what Speaker DeRoche talked about. I appreciate all the law enforcement, what they do, and put their lives on the line, and yet there are a few bad actors, and I think transparency will help bring that. I hope, and I appreciate your interest in having more transparency. Thank you. Thank you very much. And then we also have Bruce Smith with the Michigan Chiefs of Police, Southeast Michigan Chiefs Association. Would like to poses the bill package and would like to speak for 10 minutes. Okay. You can press the button there. Thank you.
Good morning. Just as a slight introduction, I'm the police chief in Chesterfield Township. I've been in law enforcement. In July, I'll be 37 years. I've worked for the Detroit Police Department, I've worked in Wayne County Agency, Macomb County Agency, and Oakland County Agency. I've been the chief or director of public safety for 10 years now at the top of 2 different departments. I'm here on behalf of the Michigan Chiefs of Police. I'm a district representative there, and also I'm the president of the Southeast Michigan Chiefs of Police. The Michigan Chiefs, as you're aware, has about 1,000 members, and the Southeast Michigan Chiefs are about 175 strong. First of all, we're opposed to this because of the significant amount of work that this is going to impose on officers and staff at a time when we're down in Michigan 4,000 police officers, and now that amount, untold numbers of clerical staff are gone. I know my department itself in the last few years has lost 25% of our patrol strength, from 49 down to 37, and several staff people who would be used to create these kinds of reports and stuff on a monthly basis. There's already mandatory annual reporting of this stuff. We have to create a annual report that goes statewide, and then also if it's a federal thing, we have to report that as well as to what was taken in forfeiture, and at the other end where it went and how it was used. And those reports are available. There's significant oversight on this forfeiture process by the prosecutors and by judges to look at what you're doing. Anything that we do, if it's challenged or if it goes through in a criminal case, the prosecutor's going to look at it, look it over to make sure it's proper and done correctly and within the law. And the same as the judge, as an independent arbitrator in these cases, is going to look over these things and makes decisions about the forfeiture independent of what we do as law enforcement. I've kind of gotten an idea of what you're looking for in some of these detailed reports. One of the things that was just brought up that gives me concern, and you talk about keeping informants or people anonymous, is that, remember, anything that we create as a report is foiable. So if you ask us to create a report that has people's names and stuff like that, that information is foiable, and we have to produce it. So keep that in mind when you're looking at creating reports. That information can get out and is out there, though. So I would just let you know that creating these reports on a monthly basis would be a significant drain on resources that we don't have. Something else to think about is a case in a civil forfeiture, and it's also, there's a criminal case involved with it. The civil forfeiture may be done in a matter of weeks, or in the cases where it goes to court, it takes time. But any of these cases, to find out the disposition of property, and for instance, if we have a drug arrest and we seize cash in a case like that, that money's held until the criminal case is disposed of. So we don't touch that. In Macomb County, certainly, all that is held, and it has to be maintained as evidence until the criminal case is over. So we may get a case in May of 2014 that is not completed until 2015, 16, 17, and then we're going back and forth with, well, what happened with this piece, with that piece, to tie those different reports in. You're looking at some potential issues that could be a problem, record-keeping wise. I think one thing that is important is that the forfeiture was created as a civil process for a different standard of law than it is in a criminal case. Criminal cases take a unanimous jury where forfeiture doesn't. I think that was the intent of this when these bills were first written, is to look at the difference in the standards and how we were affecting law enforcement and our ability to do things. I know you talk a lot about these cases of people's cars. Think about the terms of the people that are living in the neighborhoods that have to put up with prostitutes walking up and down their street every day, and having these people that are servicing the prostitutes. They're not always very nice people, and the crimes that happen in the neighborhoods where these people are at, there's some issues there that go along with it. And I think there's a great deterrent factor that goes along with some of this stuff. I think also I would just ask the committee to keep a focus on Michigan law. When you start looking at what happened in another state, their laws are not the same necessarily, and their law enforcement is not the same. I think this committee should keep its focus on what happens in Michigan and on Michigan law and Michigan law enforcement. I think we're very professional. There's other states that maybe don't have the reputation that we do. And when you start looking at something that happens in another state that's bad practice or bad law, it doesn't necessarily automatically transport to what we do in Michigan in our law enforcement. I'm just a little concerned also listening to this issue of seized evidence versus seized property for forfeiture. You know, we're looking at evidence as a criminal case. That's something that's held until the case is over and then it's disposed of. Most of this stuff goes back to the victims or insurance companies or that kind of stuff. It's a completely different thing as far as forfeiture stuff. Found property has a way to it's taken care of under state law, and the same with these things. So don't confuse evidence with forfeiture property. So, thanks.
Okay. Thank you. So just to make sure I understand, so you don't have a problem with assets being forfeited when the person's never convicted of anything? You don't have a problem with that?
I think you have to look at each individual case, but there are times, yes, when things are forfeited. With drug dealers and different kinds of issues, that stuff happens, yes.
What if it's not drug dealers? Are you still okay with that? Never convicted, never found guilty of anything, and yet the government has seized their assets. You don't have a problem with that?
I'd have to look at each individual case to say what.
No, I'm just talking about any case. I mean, you think that every time that couldn't be abused, it's fine?
Well, you're asked two questions. Could it be abused, or is it okay to not have a conviction? Yes, the courts have looked at it and they've said it doesn't necessarily have to have a criminal conviction. It's a separate process. It's a civil process.
I'm not saying with the courts. I'm saying, do you think that's right? Do you think it's right to have assets of our citizens seized and forfeited without them ever being found guilty of anything?
I think it's been upheld in the courts, yes.
I'm asking you.
Yes.
I'm asking you, do you think that's fine?
I think if it's done properly, yes.
Are you familiar with the Cade raid?
No.
No, but from what you heard, did it sound like it was probably not a good thing?
I'm really not versed on the case, so I'm not going to make any judgments about it.
Do you see the benefit? You heard Speaker DeRoche, just the whole moral, I mean, being put in situations where there's incentives that, the money goes to, a police agency, and, that there might be pressures. Wouldn't it be better if those incentives were not there, and that maybe the money went to general fund or went someplace else? Do you see that would be a benefit?
I understand what you're talking about that, and I think that criminal processes, the civil process of forfeiture, there's oversight on what happens there. Most of what is done in law enforcement is under the drug forfeiture laws. So I think it hurts the people that are doing these crimes.
Representative Townsend?
I had a tax committee hearing where we had some votes on. I apologize for being late to this proceeding. I guess I do want to, and again, I'm fairly new to this issue, so I'm going to need to do more background research on this. But I do want to make sure you're able to draw the distinction between criminal proceedings and civil proceedings. Because certainly, I mean, it seems to me, speaking, I mean, having no opinion or not trying to assert any opinion about what's happened, say, in the state of Michigan, but it seems to me, in theory at least, it's possible for a civil proceeding to occur that leads to an asset forfeiture that's legitimate. It's just a question of how it's done and whether there's proper transparency and proper accountability for how those assets are treated and what, you know, and whether there's been due process. So I'm a little uncomfortable with the idea that we're just delegitimizing the idea of asset forfeiture in civil proceedings. I don't know. I don't know if we're really the right committee to take up that issue.
We're not.
We're not. So I don't know. I just was a little troubled by the line of questioning because it seemed like you're being put on the spot to sort of evaluate, well, you know, civil proceedings versus criminal proceedings, you know. Let's unpack maybe if there have been abuses, but I wonder if we're really in the right place to talk about this issue.
Representative Robinson?
Thank you for coming, Chief. When did you work for Wayne County?
I worked for the Detroit Police Department 77 and 1980. I worked for the Romulus Police Department from 81 to 83.
You didn't work for Wayne County Sheriff's?
I said I worked in Wayne County.
Right. You said something which piqued my interest. When money is seized, you say it's put in a special account.
If it's under forfeiture, yes.
So if I am a dope, I have cocaine on me and I get arrested and I have $300 in my pocket. The $300 would go into your special account?
If money was taken under forfeiture, yes.
Well, what do you mean taken under forfeiture? Isn't every person who sees a drug case, isn't there money, don't you forfeit their money, make them post bond?
No, there's got to be some connection with the money and that it's involved with drug dealing.
Well, isn't the majority of money that's taken from a person who possesses drugs forfeited?
Not today's date. No, there was a time, yes, back in the past when money was taken that was found in conjunction with drugs or in the vicinity of. But the law has changed to say that you have to be able to show that there's some nexus between that and that the person is just not possessing something. There's some criminal activity like dealing going on.
So you let them keep their money if they don't show that nexus?
Yes.
Okay. So you don't put the money in a special account?
No, if somebody's arrested, just so we're clear on this.
I want to know where the money goes. That's what I'm asking.
Okay, well,
I'm going to lose. 1 second. I'm going to lose my majority or my quorum. So I need a motion to excuse absent members.
Yes.
Okay. Motion. Hearing no objection. Absent members are excused. Proceed.
If somebody's taken into custody, arrested, if the money's not held as evidence for whatever reason, I mean, there could be reasons why the money would be held as evidence, which when the disposition of the case is done, the courts would make a determination, does it go back to the person, what's going on with that. If somebody is just arrested, say a mere possession case, there's no connection between any drug dealing, if he's held in custody, that money would be put in his property and held until he was released, then he gets his money back. So I just want to make sure what we're talking about, that situation.
So, and where does that practice occur? Where the money is put into his property on the drug case?
In the booking process.
Now, I mean, but what communities?
Any community where somebody's taken into custody, you have to take their property from them before you put them in a cell.
I understand that. But what I'm saying, are you speaking for all the police agencies throughout the state saying they follow that practice?
Yes.
Okay, thank you. I have nothing to say.
Okay. All right. Seeing no further questions, thank you for your time. And I think we can deal with some of your issues maybe monthly. We can, and maybe we can have some appropriation. I would hope that, as we talked before, that law enforcement would see this as an opportunity and not something to stonewall, but say, I want to aggressively show that we're not doing anything wrong. Because those that are, you know, we don't appreciate the impugning of all the vast majority who put their life on the line. So I'm really hoping it'll be a can-do attitude. Let's get this done so that we can even give more assurances about what's happening. We're only talking transparency. So thank you.
All right.
Then finally, Ben Bogdan with Michigan Sheriff's Association does not wish to speak opposed to the bill. Ben, I would encourage the sheriffs to, we have a video we'll put up online. Watch that. I think maybe they'll change their mind. And again, want to assure people that it's that things are going well. And I think it would actually be a benefit, this kind of package to sheriffs. And I would hope that they'll actually be supportive. Thank you very much. We are adjourned.